Sample question paper, Legal Studies, Code 074, Class 12, Academic Session 2024-25. Time allotted 3 hours, maximum marks 80. Friends, you can pause the video and read the general instructions. Section A. Question 1. Anil Gopal Swamy has been appointed to a legal office in India under Article 76 of the Constitution. He enjoys all the privileges and immunities available to a member of parliament. Identify the position held by Anil Gopal Swamy. Answer C. Attorney General. Question 2. Which among the following is not an outcome of the oleum gas leak case? Answer D. Introduction of lead-free petrol in the country. Question 3. Assertion. State must respect all the legal rights that are owed to a person and conform to the norms of fairness, liberty, etc. Reason. Independence of judiciary is vital for the respect of due process of law. Answer B. Both assertion A and reason R are true, and reason R is not the correct explanation of assertion A. Question 4. Raj signs a contract with Suman, agreeing to sell his laptop for Rs 30,000. Suman is 17 years old. They both agree on the terms and Suman promises to pay the amount in 2 weeks. However, before the payment is made, Suman decides to cancel the deal. Which of the following is the most accurate regarding the validity of the contract? Answer B. The contract is void because Suman is a minor. Question 5. Mr. Gupta owns an apartment building where several families reside as tenants. He decides to store a large quantity of petrol in the basement of the building for his personal use, for fueling his collection of vintage cars. A month later, a minor leakage from the petrol containers led to a fire outbreak in the basement. Although the fire is quickly controlled and no one is hurt, the incident causes significant panic and stress among the residents. Is Mr. Gupta liable for causing harm to the tenants? Answer C. Mr. Gupta is liable for negligence as he breached his duty of care by storing a hazardous substance in the basement. Question 6. Saloni inherits a property under a will that also imposes certain obligations on her regarding maintaining another property. She decides to accept the inheritance but refuses to fulfill the maintenance obligations. Identify the legal principle that would apply to the given situation. Answer B. Quod approbo non reprobo. Question 7. Which of the following scenarios best demonstrates the importance of registering a trademark for a business? Answer D. A new coffee shop aims to protect its brand name and logo from being used by others. Question 8. Yash owns a large farmland in the village where he decides to construct a reservoir to supply water for irrigation purposes. The construction work was done by an independent contractor who was negligent in his work. Due to this negligence, the water escaped and flooded Mania's neighboring house and crops. This resulted in heavy losses to her. Under what legal principle is Yash liable for causing damage to Mania's property? Answer B. Strict liability. Question 9. During a neighborhood dispute, Kabir verbally threatens Veer with immediate physical harm while holding a hockey stick in a threatening manner. Kabir is within striking distance of Veer, causing Veer to fear for his safety. There is no physical contact between them during this incident. In the above scenario, Kabir is guilty for committing which tort? Answer C. Tort of assault. Question 10. Which statement best reflects the application of the doctrine of lis pendens? Answer C. When a property is under litigation, the doctrine ensures that if any right of an immovable property is in question, such property cannot be transferred by any party to the suit so as to affect the rights of any other party. Question 11. Nita Industries Limited went through an arbitration process with Mira Limited to resolve a dispute over the supply of raw materials. The arbitrator was the former CEO of Mira Limited. Nita Industries Limited was not satisfied with the arbitral award. What remedy is available to Nita Industries Limited? Answer C. Nita Industries Limited can ask for setting aside the arbitral award. Question 12. The Supreme Court of India, in its judicial decision in Afcons Infrastructure Limited versus Cherin Varke Construction Corporation Private Limited, has expressively clarified the ambit of mediation. Who among the following fall within the purview of mediation? Answer D. Cases involving international mercantile community. Question 13. A young and dedicated police officer known for his competence and integrity was assigned to a district plagued by a low literacy ratio and controlled by an education mafia involved in extorting money from students for facilitating cheating in exams. He initiated stringent measures against them and conducted raids to dismantle the illegal operations. In one of the raids, he caught the examination in charge of the school leaking the exam paper for money. He was arrested. Adarsh also arrested a head constable for taking bribes to allow the students to cheat in the examination. Unaccustomed to such resistance, Unaccustomed to such resistance, the mafia became alarmed, with some office employees tipping them off about others' determination to eradicate bribery and cheating in the district. Against whom can an action be taken under the Lokpal and Lokayukt Act 2013? Answer C. Head Constable. Question 14. Statement 1. Under Article 253 of the Constitution of India, the Parliament and the Union of India have the power to implement treaties. The Parliament and the Union of India have the power to implement treaties and can even interfere in the powers of the state government to give power to provisions of an international treaty. Statement 2. In the case of Magan Bhai Patel versus Union of India, the court held that India had ratified conventions regarding the protection of children, and this placed an obligation on the state government to implement these principles. Choose the correct statement. Answer C. Statement 1 is correct, but statement 2 is not correct. Question 15. Assertion A. Ambulance chasing is not representative of professional practice in India. Reason are: ambulance chasers are a class of lawyers who solicit business by lurking around hospitals or by ads in newspapers and yellow pages with toll-free numbers and free consultations. Answer A. Both A and R are true, and R is the correct explanation of A. Question 16. Rashi did her LLB from the University of London, UK after schooling in India. She applied for registration to the Delhi State Bar Council for enrollment as an advocate. She is 20 years old with a gold medal in her LLB. Her application for registration was rejected. What could be the probable reason for the same? Answer D. Rashi hasn't attained 21 years of age. Question 17. Assertion A. Lawyers trained in other jurisdiction will have to re-qualify to practice in foreign jurisdiction. Reason are: countries have different legal systems and laws are framed according to the social, political and civil conditions of the country. Answer A. Both A and R are true, and R is the correct explanation of A. Question 18. Which among the given statements is true for permanent Lok Adalat? Answer C. The award of permanent Lok Adalat shall be final and deemed to be a decree of a civil court. Question 19. In the case of State versus Bhuvan, the accused Bhuvan was convicted under Section 302 of the IPC for the murder of his wife Jaya. The conviction was primarily based on the dying declarations made by Jaya. A police officer recorded these declarations and were subsequently also recorded by a metropolitan magistrate who visited Jaya in the hospital. Can Bhuvan be convicted of murder based on Jaya's dying declaration? Answer B. Bhuvan can be convicted solely based on Jaya's dying declaration, provided the declaration is found to be true, voluntary, and made in a fit state of mind. Question 20. Analyze the two statements given below and select the correct option. Statement 1. The physical element of crime needs to be complemented by the mental element. Statement 2. Mens rea by necessary implication can be excluded from a statute only where it is absolutely clear that the implementation of the object of a statute would otherwise be defeated, and its exclusion enables those put under strict liability by their act or omission to assist the promotion of the law. Answer A. Both statements are correct. Section B. Question 21. First, analyze the role of regulators in aiding the tribunals. Substantiate the answer with the help of an example. Answer. Regulators are specialized government agencies that oversee law and order compliance in the relevant government sectors. For example, one of the tribunals, TDSAT, functions alongside the regulator, TRAI, Telecom Regulatory Authority of India, in formulating laws and policy for resolving telecom disputes in India. Second, or second, explain the seniority principle of the appointment of Chief Justice of India. How is the seniority determined? Answer. The Chief Justice of India is the senior most judge of the Supreme Court. Seniority is determined on the basis of the date of their appointment to the Supreme Court, and if two judges are appointed to the court on the same day, the judge who takes the oath first is the senior judge. Question 22. Aarti Gupta and Sia Khanna approached the secretary of their housing society to solve a dispute regarding the common area shared by both families. The secretary mediates and discusses their issues. The mediator then decides on a solution for the Guptas and Khannas and tell them to adhere to it as it is legally binding. Aarti Gupta and Sia Khanna feel that they should have approached the Lok Adalat instead of the secretary for mediation. First, identify any two errors in the mediation process mentioned above. Answer. A. Deciding the solution. B. Ask the parties to adhere to his decision. Second, state the kind of cases that can be referred to a Lok Adalat. Answer. A. Civil suits. B. Compoundable criminal disputes. Question 23. First, judicial precedent is an important source of law in domestic legislation but not in international law. The judicial precedent of ICJ is a secondary source of law. Comment. Answer. Judicial decisions and the teachings of publicists are sometimes referred to as secondary sources or evidence of international law. The court may have jurisdiction to decide cases in which the parties agree to appear before the court on their own behest and agree to be bound by the decision of the ICJ. Article 59 of the Statute of the ICJ states that decisions of the ICJ have no binding force except on the parties to the dispute. Therefore, past decisions of the ICJ are not binding. However, ICJ does refer to its past opinions when deciding new cases. The ICJ tends to examine its previous decisions, determine which cases should not be applied, and rarely departs from the relevant case law. Also, Article 38 of the Statute of the International Court of Justice (ICJ) mentions judicial decisions as a subsidiary means for the determination of rules of law. Second, international customary law is the most disputed and discussed source of international law. Comment. Answer. Customary international law is comprised of two elements. A. Consistent and general international practice by states. It is the widespread repetition of similar international acts over time by states, that is state practice, and B. A subjective acceptance of the practice as law by the international community. The requirement that the acts must occur out of a sense of obligation, that is opinion juris. International customary law is probably the most disputed source of international law. For example, it is not clear when a particular state practice becomes a legally binding state practice. It is also unclear how one can identify a rule of international custom or how one can prove its existence. Question 24. First, why does allowing advertising by lawyers require a balancing act? Answer. The issue of allowing advertising and solicitation by lawyers requires balancing the interest of the public, which includes getting information on legal rights and services through advertisements and enhancement of access to justice and the legal profession on one hand, and the possible misuse of advertising techniques by lawyers, which may lead to a loss of credibility of the profession as a whole. Or second, who is a Judge Advocate General JAG officer? State the role of the JAG department. Answer. Judge Advocate General is the legal and judicial chief of the army and advises the chief of the army staff on legal matters. A. The JAG's department is also responsible for emerging fields of military law such as those related to cyber laws, space laws, terrorism and human rights violations. B. It deals with military related disciplinary cases and litigation and assists in providing legal assistance to the army in human rights matters and the rule of law among other things. C. The service rendered in the JAG's department are considered to be judicial service as per the regulations for the Indian Army. So friends, you can write any 2 points from the given 3 points. Question 25. Litigation is not a luxury but it should be used as a last resort. Analyze the statement with respect to pre-litigation services. Answer. These days, the number of litigations is increasing day by day, which is against the smooth administration of justice. So far, emphasis was given only on post-litigation assistance or help. Now, it is being realized that pre-litigation legal services are more useful than post-litigation legal services. The pre-litigation legal service include legal education, legal advice, legal awareness, and pre-litigation settlement. Post-litigation services include all those services that are required to be rendered by an advocate to his client. These services should be restored only. These services should be resorted only when pre-litigation services fail to give any result. Question 26. Arjun offers to sell his bicycle to Bhavna for Rs 3000. Bhavna agrees to buy the bicycle at the said price and promises to pay the amount the following week. They decide to write down their agreement on a piece of paper which both sign. Identify the 4 essentials of a valid contract in the situation given above. Answer. First, an agreement is the result of a proposal or an offer by one party and its acceptance by the other. Second, competent parties. The parties to the agreement must be competent to enter into a contract. Third, lawful consideration and lawful object. There must be lawful object and lawful consideration in respect of the agreement. Fourth, free consent. There must be free consent of the parties, that is free from coercion, undue influence, fraud, misrepresentation and mistake when they enter into the agreement. Fifth, not expressly declared as void by the law. The agreement must not be the one which has been declared as void by the law in force at the time of entering into the agreement. So you can mention any 4 points. Question 27. Tamil, Telugu, Gujarati speaking people living in Delhi are among the many minority communities. What rights do they have with regard to their language and culture while living in Delhi? Answer. Tamil, Telugu, Gujarati speaking people living in Delhi are linguistic and cultural minorities. They are afforded protection under Article 29 and 30 of the Indian Constitution. First, any minority group having a distinct language, script or culture of its own shall have the right to conserve the same. No citizen shall be denied admission into any educational institution maintained by the state or receiving aid out of state funds on grounds only of religion, race, caste, language, or any of them. Second, all minorities, whether based on religion or language, have the right to establish and administer educational institutions of their choice. In making any law providing for the compulsory acquisition of any property of an educational institution established and administered by a minority. Question 28. The right to constitutional remedies is the most important fundamental right. Justify the given statement. Answer. Fundamental rights are justiciable rights. They are enforceable as every individual has the right to seek help from courts if they are violated. Encroachment or violation of fundamental rights in our day-to-day life is a matter of great concern. This is why our constitution does not permit the legislature and the executive to curb these rights. It provides legal remedies for the protection of our fundamental rights. When any of our rights are violated, we can seek justice through courts. We can directly approach the Supreme Court that can issue directions, orders or writs. for the enforcement of fundamental rights. Section C, question 29 first. Who is an amicus curiae? When can an amicus curiae be appointed in civil and criminal matters? Answer. Amicus curiae, literally translated from Latin, is friend of the court. If a petition is received from the jail or in any other criminal matter, if the accused is unrepresented, then an advocate is appointed as amicus curiae by the court to defend and argue the case of the accused. In civil matters also, the court can appoint the advocate as amicus curiae if it thinks it necessary in case of an unrepresented party. The court can also appoint amicus curiae in any matter of general public importance or in which the interest of the public at large is involved. Or, second, state the rationale behind increasing the retirement age of judges in India. Answer. A. The judge population ratio in India is among the lowest in the world. It is also necessary to increase the number of judges in the pool to enable the judiciary to deal with the enormous pendency of cases. B. Moreover, legislations provide for retired High Court and Supreme Court judges to maintain tribunals till the age of 70 as chairmen and 65 as members. There is no reason why these judges should be retired so early. C. One aspect which has not been factored in is that as the Indian economy grows, the ratio of litigation to population will increase exponentially. Advanced economies such as Australia, Canada, France, the US, the UK, and Japan have much higher litigation to population ratios. D. Several senior lawyers with requisite expertise and experience decline to accept judgeship due to the lower retirement age of 62, especially in the high courts. By an enhanced age, this problem could be rectified as advocates would have greater incentive to forego their individual legal practice and function in the role of judges. E. Further, the relatively early retirement age in India is often linked to the declining quality of judicial service and the inability of a judge to properly effectuate the stipulated judicial workload. Question 30. First, give any three differences between arbitration and mediation as alternative dispute resolution methods. Answer. Arbitration. Arbitration is a private arrangement of taking disputes to a less adversarial, less formal, and more flexible forum and abiding the judgment of a selected person. Mediation is a method of ADR in which parties appoint a neutral third party who facilitates the mediation process in order to assist the parties in achieving an acceptable voluntary agreement. Arbitration. Role of an arbitrator is that of an adjudicator. Mediation. Role of a mediator is that of a facilitator. Arbitration proceedings end with a binding award by the arbitrator. Mediation proceedings are successful when the disputing parties mutually arrive at a decision. Mediator does not suggest any solution to the parties. Or, second, what are the problems confronted by the law courts in India? How can ADR help in resolving these problems? Answer. A. The lack of number of courts and judges creates an inadequacy within the justice delivery system. B. The increasing litigation in India due to increasing population, the complexity of laws and obsolete continuation of some pre-existing legal statutes. C. The increasing cost of litigation in prosecuting or defending a case, increasing court fees, lawyers' fees, and incidental expenses. D. Delay in disposal of cases resulting in huge pendency in all the courts. Delay in disposal of cases resulting in huge pendency in all the courts. The ADR techniques are a speedier, informal, and cheaper mode of dispensing justice when compared to the conventional judicial procedure. Question 31. Mr. Baiju hired Mr. C. Tiwari for a land acquisition case who was enrolled as an advocate with the Bar Council of UP and has been practicing in the district courts of UP. Mr. Baiju won the case and the state deposited a compensation of rupees 8,118 in the court. Mr. Baiju was an old, helpless, poor illiterate person. Mr. C. Tiwari withdrew the said amount from the court on behalf of his client and did not inform or return that amount to him. When Mr. Baiju came to know about the withdrawal, he approached Mr. C. Tiwari for a refund. When Mr. C. Tiwari refused on the pretext that it was adjusted against the professional fee outstanding towards Mr. Baiju. First, is the conduct of Mr. C. Tiwari justified? Give reasons. Answer: no. His action is against the professional ethics laid down by the Bar Council of India. Second, who has the authority to initiate action against Mr. C. Tiwari, if any? Answer: State Bar Council of UP. Third, what can be the consequences of the act of Mr. C. Tiwari? Answer: breach of these rules and standards of conduct led to disciplinary action against advocates, which may result in suspension or debarment. Question 32. Identify and explain the type of transfer that is being done in each of the following cases. First, Mr. Singh owns a piece of land and decides to sell it to Mr. Jolly. They both agree on a price and the transaction is completed with a signed contract. Answer: sale. Mr. Singh has transferred his piece of land to Mrs. Jolly by sale. Sale means a transfer of ownership, right to possess something of the property in exchange for a price, that is money, section 54 of the TPA. Second, Uday has a beach house and Lalita has a small lodge in the mountains. Uday's dream is to own that lodge and Lalita wants to own the beach house. They both agree that the properties have similar values and want to fulfill their dreams. Answer: exchange. Uday and Lalita have transferred their respective properties to each other by exchange. When two persons transfer ownership of one thing for the ownership of another, it is called exchange. Section 118 of the TPA. Transfer of property by exchange can be made only by way of sale. The rights and liabilities of the parties to exchange shall be that of the rights and liabilities of the buyer to the extent of receiving and that of the seller to the extent of giving. Third, Priyanka has a valuable collection of antique jewelry that she inherited from her grandmother. She decides to give a portion of his collection to her daughter, Malti, as a token of their bond and shared memories with their grandmother with no monetary exchange involved. Answer: gift. Priyanka has given inherited jewelry as a gift to her daughter Malti. A transfer of ownership of property that is made voluntary and without consideration is called gift. Section 122 of the TPA. Question 33 first. In the wake of Bhopal gas tragedy, which act was passed by the Government of India under Article 253 of the Constitution? State the main provisions of this act. Answer: in the wake of the Bhopal tragedy, the Government of India enacted the Environment Protection Act of 1986 under Article 253 of the Constitution. A. The purpose of the Act is to implement the decisions of the United Nations Conference on the Human Environment relating to the protection and the prevention of hazards of human activities for economic development to human beings, other living creatures, plants and property. B. The Act is an umbrella legislation designed to provide a framework for the central government to coordinate the activities of various central and state authorities established under previous laws such as the Water Act and the Air Act. Or second, name the statutory organization established under the Water Prevention and Control of Population Act 1974, which works under the supervision of the Central Pollution Control Board to implement the environmental laws. List the objectives and functions of this statutory organization for the protection of the environment. Answer: the State Pollution Control Board is a statutory organization established under the Water Prevention and Control of Pollution Act 1974. Objectives: A. Preservation of natural resources. B. Promotion of sustainable development for economic growth of the nation along with environmental protection and social equity. C. Effective waste management for the protection of the environment. D. Spreading awareness about the protection of the environment among the consumers. E. Encouraging the general public for the use of environment friendly products like paper bags, public transport, CFL, etc. to help reduce the environmental pollution. So friends, you can write any two objectives. Next, functions. A. Issue NOC, no objection certificates from the perspective of the environmental pollution. including the adequacy of the site from the environmental angle. B. Assessment of quality ambient air. C. Assessment of inland surface waters quality. D. Assessment and identification of municipal and industrial pollution sources and control. E. Conducting mass awareness programs. F. Development of pollution control technologies. G. Notification of emission and effluent standards. H. Instituting legal action against defaulters. You can write any two functions from the given. Question 34. What are human rights? Explain how fundamental rights and human rights are important to create a better environment for people and to help them preserve their dignity. Answer. Human rights are basic rights that we have because we exist as human beings. These are not granted by any state. Human rights belong to all human beings irrespective of their nationality, race, caste, creed, gender, etc. All individuals enjoy the same human rights without any discrimination. Human rights are safeguards that a human being seeks to live with dignity and equality. Therefore, human rights are universal and inalienable rights. The principle of universality of human rights means that we are all equally entitled to our human rights. Human rights are inalienable, therefore, these should not be taken away except in specific situations and according to due process. For instance, the right to liberty may be restricted if a person is found guilty of a crime by a court of law. A few examples of human rights are those basic rights that ensure fairness, equality, freedom, and respect to all people. These rights abolish various unjust practices like exploitation, discrimination, and inequality. Human rights include most fundamental rights like the right of life, rights of food, education, work, health, liberty, etc. Fundamental rights are basic rights of the citizens of a country. Fundamental rights are enshrined in the Constitution and they are enforceable in the court of law. If there is any kind of violation of fundamental rights, one can approach the court for the protection of such rights. Question 35. A national daily had the following news article on the plight of children in rural areas of a district. A daily wage earner had a big family to support. To arrange for resources to marry his daughter, he gave away his two sons, Golu and Mohan, to a Bengal making unit in Ghoshabad district. In another instance in the same district, there have been reports of trafficking of young girls between the ages of 5 to 10 years. First, identify the quasi judicial body that has jurisdiction over such matters. Answer. NCPCR, National Commission for Protection of Child Rights. Second, state any four functions of this organization that aim to build an atmosphere in favor of protecting children's rights. Answer. Functions. A. Examine and review the safeguards provided by or under any law for the time being in force for the protection of child rights and recommend measures for their effective implementation. B. Present to be central government annually and at such other intervals as the Commission may deem fit. Reports upon working of those safeguards. C. Inquire into violation of child rights and recommend initiation of proceedings in such cases. D. Examine all factors that inhibit the enjoyment of rights of children affected by terrorism, communal violence, riots, natural disaster, domestic violence, HIV/AIDS, trafficking, maltreatment, torture and exploitation, pornography and prostitution, and recommend appropriate remedial measures. E. Look into the matters relating to the children in need of special care and protection, including children in distress, marginalized and disadvantaged children, children in conflict with law, juveniles, children without family, and children of prisoners, and recommend appropriate remedial measures. F. Study treaties and other international instruments and undertake periodical review of existing policies, programs, and other activities on child rights and make recommendations for their effective implementation in the best interest of children. Question 36. The Povartis Pharmaceutical Company was granted patent rights for the novel and inventive compound Curtinib used to treat non-small cell lung cancer. They came across a product of Matco Pharma during a pharmaceutical conference held in Delhi about the launch of a product called Certinib capsules. Matco Pharma claimed that the Certinib molecule is neither novel nor insensitive as it comes within the broad Markush formula. Povertis filed a case against Matco Pharma seeking a permanent injunction and damages in respect of its granted patent and restraining Matco Pharma from manufacturing and selling the Certinib capsules. First, could Matco Pharma launch its product Certinib capsules? What is the purpose of patent laws in India? Answer: no. Patent is a statutory right for an invention granted for a limited period to the patentee by the government in exchange for full disclosure of his invention for excluding others from making, using, selling, or importing the patented product or process for producing that product for those purposes without his consent. Second, what requirements were fulfilled by Poverty's pharmaceutical company for their idea to qualify as a patentable matter? Answer: the requirements fulfilled by the Poverty's company to qualify their idea as patentable matter are: A. Novelty. The invention must contain one or more unique and new elements. B. Non-obviousness. Simple or obvious changes to an existing invention cannot be called an invention. The invention must be a notable change in the field. The particular feature must add to existing technical knowledge, that is, in terms of uniqueness and commercial viability. And C. Industrial application. The invention must have some utility. The invention is patentable if it is capable of commercialization. Section D, question 37, first A. What is a contract? Answer: according to Section 2H of the Indian Contract Act 1872, an agreement that is enforceable by law is a contract. B. Explain the four types of contracts based on the validity of contracts. Answer: types of contract based on the validity and enforceability of contracts are: first, valid contract, void contract, violable contract, illegal contract, and unenforceable contract. First, valid contract. According to the Indian Contract Act 1872, an agreement that is enforceable by law is a contract. Section 2H. A valid contract is a legally binding agreement between two or more parties that is enforceable by law. This implies all agreements per se are not contracts. Void contract. A contract which ceases to be enforceable by law becomes void. Voidable contract. It is a contract that may either be affirmed or rejected at the option of one of the parties to the contract on grounds of coercion, undue influence, fraud, or misrepresentation. Illegal contract. According to the Section 10 ICA, a contract must be made for a lawful consideration and lawful object. If either the consideration or the object is an action or omission prohibited by law, it results in an illegal contract. Unenforceable contract. An unenforceable contract is a contract that may have the essential elements of a valid agreement but cannot be enforced by one or more of the parties in a court of law. This can happen for several reasons, such as: A. Lack of capacity due to age, minors, mental disability, or intoxication. The contract can be considered unenforceable. B. Lack of consent. If the agreement was entered into under duress, fraud, undue influence, or misrepresentation, it might be deemed unenforceable because the consent was not freely given. Or second A. What is meant by intellectual property? Answer: intellectual property is an intangible property that comes into existence through human intellect. It refers to the creation of the mind or products of human intelligence such as inventions, designs, artistic work, names, symbols, images, etc. B. Explain the evolution of Indian IPR laws through any three international conventions on IPR. Answer: the Paris Convention for the Protection of Industrial Properties. First, national treatment. In the context of legal protection for industrial property, the principle of national treatment requires each member country of the Paris Convention to provide equal legal protection for the inventions of nationals from other member countries, as it would for its own national. Second, framework of priority. The Paris Convention also upholds the principle of priority framework, allowing an inventor to protect their invention simultaneously in various countries. Second, the Berne Convention for the protection of literary and artistic works. First, national treatment stipulated that any work originated in a contracting state, including works of authors who are nationals of that state or works first published in that state, should receive the same legal protection in every other contracting state as the latter state grants to its own nationals. Second, automatic protection mandated that legal protection should not be subject to compliance with any formalities. Third, independence of protection decreed that legal protection should be independent of the existence of protection in the country of origin of the work. Third, the Universal Copyright Convention UCC. National treatment. The UCC adheres to the principle of national treatment rather than automatic protection, which implies that contracting countries are not obligated to provide foreign works with automatic protection if the national requirements are not met. Second, the term of work under the UCC, original literary, artistic, and scientific works are eligible for protection. To provide reasonable notice of the copyright claim, a copyright notice should accompany the work. The UCC stipulates that protection for a work lasts for the duration of the author's lifetime and an additional 25 years following the author's death. Third, minimum rights. As per the UCC's provisions, the contracting countries must provide a specific set of minimum rights to the lawful owner of the work, provided they do not create any conflict with the spirit of the convention. Question 38 first. Explain the process of constitution of the panel for providing free legal aid under the NELSA Regulation 2010. Answer. The Legal Services Institution is vested with the authority to invite applications from legal practitioners with requisite professional experience to indicate the type of cases as they may be interested with. The panel shall be prepared by the executive chairman of the legal service institution in consultation with the Attorney General for Supreme Court, Advocate General, Advocate General for High Courts, Government Pleader for District Talaks, and the Bar Association President. B. The legal practitioner shall have 3 years or more of experience at the bar for being considered for empanelment. Personal traits like competence, integrity, suitability, and experience shall be considered. C. Separate panels shall be maintained for different types of cases. D. The regulations also provide for retainer lawyers. E. The panel has to be reconstituted every 3 years without disturbing the work of panel lawyers already representing ongoing cases. In such cases where the panel lawyer wishes to withdraw from a case entrusted to him, shall communicate this to the member secretary and the latter may permit him to do so. Second, explain sequentially the enactment of the Legal Services Authorities Act 1987. Answer. The 14th Law Commission of India report on reform of judicial administration 1958 mooted the idea of providing free legal aid to the poor by the state. The report highlighted the responsibility of the legal community to administer legal aid schemes and the state to fund legal representation to the accused in criminal proceedings, appeals, and jails. B. In 1960, the Union government initiated the National Legal Aid Scheme, which faced financial shortages and died a natural death. C. In 1973, in the second phase, the Union government constituted a committee under the chairmanship of Justice Krishna Iyer to develop a legal aid scheme for states. The committee devised a strategy in a decentralized mode with legal aid committees in every district, state, and center. D. In 1980, a committee was constituted at the national level to oversee and supervise legal aid programs throughout the country under the chairmanship of Justice P. N. Bhagwati, then a judge of the Supreme Court of India. This committee came to be known as SALES, Committee for Implementing Legal Aid Schemes, and started monitoring legal aid activities throughout the country. E. In 1987, the Legal Services Authorities Act was enacted to give a statutory base to legal aid programs through the country on a uniform pattern. Subsequently, the Parliament enacted the Legal Services Authorities Act 1987 to provide free legal aid to certain categories of citizens. Question 39. Trepal, a mountainous country rich in medicinal herbs, has a flourishing domestic market of Ayurvedic medicines. Gokushal Limited received a big order for its famous Guduchi herbal tea from its neighboring country, Dranse. This was one of the biggest orders that the company ever received. But the very first lot was rejected by Dranse as the herbal tea failed the stringent quality and generic medicine test. Dranse also cancelled the remaining order. Gokushar Limited was very disappointed and approached the government agencies of his country for help. First, which category of international law is involved in the problem stated above? Answer: Public international law. Second, which organization will be instrumental in resolving the problem between the two countries? State the role of this organization in the modern day scenario. Answer: The World Trade Organization WTO. The World Trade Organization WTO is the only global international organization dealing with the rules of trade between nations. It is an intergovernmental organization that regulates and facilitates international trade. At its heart are the WTO agreements negotiated and signed by the bulk of the world's trading nations and ratified in their parliaments. The goal is to help producers of goods and services, exporters and importers conduct their business. It is a forum for governments to negotiate trade agreements. It is a place for them to settle trade disputes. WTO is a place where member governments try to sort out the trade problems they face with each other. Question 40. Ravi and Deepa decide to open a gourmet coffee shop in Bengaluru. Ravi contributes rupees 1,50,000 and Deepa contributed rupees 250,000 to the startup capital. They do not formalize their business agreement in writing, instead rely on their strong personal trust and mutual understanding. They verbally agree to share profits and losses equally. The coffee shop thrives in the first 6 months, generating a substantial profit. However, disagreements soon arise. Ravi feels he should receive a larger share of the profits to compensate for his active day to day shop management. At the same time, Deepa argues that their initial agreement to share profits equally should stand. In light of the above scenario, answer the following questions. First, identify the type of legal entity formed by Ravi and Deepa. Answer: Partnership firm. Second, state the silent features of this type of entity. Answer: The nature and essential characteristics of partnership firms. A. No separate entity. A partnership firm has no separate legal existence of its own. That is, the partnership firm and the partners are the same in the eyes of law. B. Unlimited liability. Partners are jointly and severely liable for the liabilities of the firm. C. Profit. Partners share profits in a mutually agreed ratio. D. Liability. First, unlimited liability. Second, partners are jointly and severely liable for the liabilities of the firm. E. Control and decision making. Partners enjoy shared responsibility amongst each other. This may sometimes raise conflicts in decision making. Third, discuss the potential issues arising from their lack of a formal written agreement under Indian partnership law. What could have been done differently to prevent these disputes, and how should they proceed to resolve their current disagreement? Answer: Importance of a written agreement. The Indian Partnership Act does not mandate the partnership agreement to be in writing. However, having a written partnership deed is considered best practice for avoiding disputes. Given the absence of a written agreement between Ravi and Deepa, there should be an equal sharing of profits and losses unless there's proof of an agreement to the contrary. This default position is a protective measure but can lead to disputes when partners have different expectations. Friends, we have completed sample question paper for Legal Studies code 074 of class 12. If you like the video, kindly like it and share it with your friends. Thank you for watching.